You remember last year, after a thorough and very rigorous investigation by Pam Bondi and all of the people at Department of Justice, the FBI, the CIA, the White House counsel's office, and the Department of everything. We have a Department of everything. You know what that is? I think that's called the White House. Into a terrible situation caused by a man named Sleepy Joe Biden. He used an auto pen last year for the turkey's pardon. So I have the official duty to determine, and I have determined that last year's turkey pardons are totally invalid, as are the pardons of about every other person that was pardoned other than, where's Hunter? No, Hunter's was good. That was the one pardon, Pam, that was good, right? The rest of them are all invalid. I don't know what the hell you're going to do about that, but now we're going to take a little of the joking. That is a mess. But they're hereby null and void. The turkeys known as Peach and Blossom last year have been located, and they were on their way to be processed. In other words, to be killed. But I have stopped that journey, and I am officially pardoning them. And they will not be served for Thanksgiving dinner. We saved them in the nick of time. This one has plenty of time, but they were saved in the nick of time. We're thrilled to be.
Good evening, everybody. Welcome to the Vibe program. I am your host, Joe Neerman, a.k.a. Good Lawgic. Hope you had a good day. Hope things are going well for you. I've got three main stories tonight. Three main topics that I plan on covering with you all this evening. First and foremost, I plan on spending some time looking at a story that you likely have not heard much about, a crazy story involving a leftist judge who decided that she doesn't like the jury's verdict. So she's just overturning it and letting a guy who was found guilty unanimously beyond a reasonable doubt by 12 different members of the Hennepin County jury system of committing fraud in the amount of $7 million. And she's like, not so much. And she let him walk. We're going to break down that decision and give you some thoughts about where she seems to be coming from in the law and why it's so unusual. And I want to sort of dissect her thinking so I can sort of walk her, in case she's watching this show, which she should be. I want to explain to her where it is that her analysis seems deeply flawed. And I'm going to walk you all through that. Also, there have been development. There's an ongoing story with Mr. Swalwell out of California, who's currently running for governor of that beleaguered state. And there's been some investigations where he's got Tish James kind of problems there with what he's been doing with his mortgages, which seem to have a legal impact on his ability to actually run for governor or even serve theoretically as a member of the House on behalf of the state of California. Or the once great state of California is how we should refer to them, right? They're not the great state. They're the once great state of California. And finally, there are further developments with respect to the Seditious Six. In fact, the Seditious Six seem as if they might be coming to the Seditious Seven. So we're going to look at that and those developments there with some awesome trolling coming from Pete Hegseth of Senator Mark Kelly. And so we're going to definitely take a look at that as well. Finally, I haven't put it in there. I'm trying to list it as a goal. In fact, that's one of the reasons it took me a few seconds here. I was trying to get this goal up and going, and for one reason or another, it doesn't seem to want to show. But my goal that I want to put up here is that there is a report of a fallout between Trump and Kash Patel, which may lead to his removal. And I think that it's kind of insane. But I want to break down for you more about that story and why it is that story may be coming out and give you my thoughts on that. All of that and more. Well, maybe not more, but all of that is coming up during the course of the show. If you like what you hear, I urge you, please make sure you click like, share, subscribe, all that good stuff. Drop a comment down. Give me your thoughts. Tell me what's going on in your mind, because your feedback to me is invaluable. With that, let's start with the first story that we had up here today, which is specifically the story of this that came out of Minnesota, which has just confused the bejesus out of a lot of people and had them screaming in outrage at this leftist judge who decided, let's let this guy walk. You probably don't know this story. So in order to give you some background for it, I'm going to walk you back to August 12th, 2025. That's the date that there was actually a press release that came from the Minnesota Attorney General. That's Keith Ellison gave out a press release. And when he gave that press release, he made clear how excited they were to get a conviction of a defendant whose name was Abdi Fattah Yusuf, found guilty of bilking a Medicaid program out of over $7.2 million. And they walked through exactly what happened there. And since I, before today, didn't know anything about this story, and you likely know little about it, let's break down exactly what this guy was found guilty of doing by, again, a 12-member jury found guilty beyond a reasonable doubt. Unanimous. It took them 4 hours thereabouts to convict this guy. That's how overwhelming they found the evidence to be, the evidence that would later be completely set aside by a judge. And we're going to look at that judge also. Blaine Mann owned agency that operated out of a mailbox, yet claimed to provide over millions in home and community-based services to Medicaid recipients. So this was on August 12th, 2025, 3.5 months ago. Minnesota Attorney General Keith Ellison announced that today his office's Medicaid Fraud Control Unit obtained guilty verdicts at the criminal trial of Abdi Fattah Yusuf in Hennepin County. I'm assuming that sounds like an Irish name to me. A jury found Yusuf guilty of 6 counts of aiding and abetting theft by swindle of over $35,000. The jury also found multiple aggravating factors existed to support an upward departure from the Minnesota sentencing guidelines. So not only has he done it, but he probably should serve serious time here. Yusuf will be sentenced before the Honorable Sarah S. West at a later date to be set by the court. Unfortunately, these words did not prove to be prescient, at least so far. In June 2024, Attorney General Ellison's MFCU charged Yusuf with bilking the Minnesota Medical Assistance Program, Medicaid program, through his agency, Promise Health Services LLC. So we're going to keep referring to Promise when we're going through this story. And Promise is the limited liability company that this individual created for the purposes of, or which he, shouldn't say he created for that purpose, but he certainly used, according to these 12 unanimous jurors, this agency, Promise Health Services. He used Promise to bilk the Medicaid system. Promise claimed to provide home and community-based waivered services, but it lacked any office building, operated for years out of a mailbox. Yusuf and his family members fraudulently obtained Medicaid funds by billing for services not provided, services that were billed based on false documentation, services that were overbilled, services that were billed but lacked any documentation to support the services, and kickbacks provided to recipients to induce them to receive services from the agency. While Yusuf operated Promise, the agency stole over $7 million. MFCU investigators determined that Yusuf frequently used the money stolen from the Medicaid program to fund a lavish lifestyle for himself and his family, including directing over $1 million from the Promise business account into Yusuf's personal account. His personal account it came into. That's an important little tidbit, that he has $1 million coming from this into his personal account. You'll see why later, but the fact that he has $1 million coming from this company into his account is something that should be highly relevant in this story. But I digress. We'll get there. We're gonna get there. So he's got over $1 million going to his account and withdrawing over $387,000 in cash. Yusuf and his wife also spent more than $22,000 at furniture stores, despite promise lacking any physical office space. Spent over $42,000 at luxury automotive dealers, obviously. You know the Irish and their cars. And over $80,000 at luxury clothing stores, including Coach, Canada Goose, Michael Kors, Third Degree Heat, Nike, and Nordstrom. Stealing money, quote, stealing money meant for poor people, healthcare, and using it to buy luxury cars and designer clothes is as shameful and disgraceful as it gets, said Attorney General Keith Ellison. Minnesotans believe in helping our neighbors. Tim Walz believes in helping everyone's neighbor. But we have no patience for fraudsters like Abdi Yusuf, who abuse that generosity to enrich themselves. I am pleased that my office convicted Yusuf, and I am committed to recovering as much of the money that he stole from taxpayers as possible. This case was the product of a joint investigation by MFCU, and they had substantial assistance, blah, blah, blah. Here are our thank yous. But now you have a general feel for what happened. Right? He goes into why this is significant, that they receive 75% of their funding from the U.S. Department of Health and Human Services under a grant awarded totaling $4.4 million, federal fiscal, remaining 25% of $1.4 million is funded by the state of Minnesota. So there you go. All right. That's the story. That's what happened there. That's how that was the world as of August 12th, 2025. But then we have the world today. And this is the story that broke out today.
At the August trial for Abdi Yusuf, the jury heard evidence that he ran his home health care company, Promise Health, out of a mailbox at a Central Avenue address where multiple other home health care companies were supposedly located. Yusuf and his wife, Lol Ahmed, were charged with stealing $7.2 million of taxpayer money through Medicaid overbilling in a personal care assistant, or PCA, scam. The couple allegedly spent tens of thousands of the fraud money on luxury items for themselves. Despite the jury swiftly convicting Yusuf, Judge Sarah West last week decided they got it wrong.
It's reversing or overturning a jury's verdict.
Defense attorney Joe Tamburino, who's not affiliated with this case, reviewed the decision and analyzed it for KARE 11 News. He says Judge West ruled that the state's case relied heavily on circumstantial evidence and that she believed the state did not rule out other reasonable inferences. Yes, that's right. Didn't rule out other reasonable inferences. Okay.
That in fact there could have been other reasonable theories
for $1 million going into his personal bank account from this company. Okay.
other than guilt in this case. That's what it comes down to.
Despite the ruling, even Judge West wrote that she is troubled by the manner in which fraud was able to be perpetuated at Promise Health.
I was stunned.
State Representative Kristen Robbins, chair of the House Fraud Prevention and State Oversight Committee, says she's now reviewing if any state laws need to be tightened.
We want to strengthen state law so that we can get prosecutions out of these cases, because clearly a jury thought he was guilty.
Jurors in the case can't believe the decision.
I'm shocked. I'm shocked based off of all of the evidence that was presented to us and the obvious guilt that we saw based off of the said evidence. It was not a difficult decision whatsoever. The deliberation took probably 4 hours at most. Based off of the state's evidence that was presented, I was beyond a reasonable doubt.
The attorney for Mr. Yusuf, Ian Burrell, sent me a statement today that says, in part, Judge West's ruling affirms what we have maintained from the beginning, that our client, Mr. Yusuf, was wrongfully accused and did not commit fraud or racketeering.
Obviously.
The Attorney General's office filed an appeal this afternoon. So the Minnesota Court of Appeals will take a second look at this decision, Julie.
So, Lou, did Mr. Tamburino, did he have any kind of emotional reaction? This is pretty stunning. This does not happen.
Does not happen. This never happens. You have to, in order for, this is called judgment notwithstanding the verdict. it is in every judge's power across the country. Every judge could be overturning jury verdicts. This never happens. This never happens. I mean, it could happen, but it never happens. Yet it happened here.
Towards the idea that this was kind of a one-off and that it would have a good chance at appeal. But the worry is that there's so many other cases just like it where somebody's in the exact same position as Mr. Yusuf, but is charged.
And by the way, circumstantial evidence is not just evidence. It is usually the overwhelming amount of evidence they have is circumstantial. Fingerprints are circumstantial evidence. We always rely upon circumstantial evidence. It is silly to disparage circumstantial evidence. You know, when you don't, the opposite of circumstantial evidence is when someone says, I am an eyewitness that I saw XYZ happen. Most cases will have a combination of direct, that's considered direct evidence, and circumstantial evidence. But the most compelling evidence is almost always going to be the direct evidence. Excuse me, the circumstantial evidence is often going to be the most compelling part of it, right? When you find fingerprints, DNA, all this stuff that implies that someone was there, it doesn't say for sure, but it tells us that, well, these fingerprints were on this gun. That's circumstantial evidence. So yeah. Now, to be clear, there are different levels amongst circumstantial evidence as far as how weighty or how reliable circumstantial evidence could be. Some circumstantial evidence could be far less reliable. And indeed, you have to have circumstantial evidence, which is going to be, it's usually you want to have it corroborated with some sort of direct evidence. But yes, circumstantial evidence is indeed significant evidence often. Not always. Some circumstantial evidence could be really like no big deal. Like, the guy's jacket was wet, so we know that he was out in the rain. It's like, okay, maybe. Could have been a lot of other ways it got wet. He could have been walked under a pipe or something like that. So that's less weighty type of circumstantial evidence. But you're correct in your statement.
With fraud, and if the judge can determine that maybe they didn't know that the fraud was going on underneath them in the case, then other judges could throw it out just like this one.
All right. Do you know how quickly the Court of Appeals would take this up? Any idea?
Probably months.
All right. Thank you.
It probably would be months. That's an accurate call. The Court of Appeals in most states, and I have no reason to assume that Minnesota is any different, they tend to take a while. They tend to take a while to get where they're going. So we're going to look at that decision because I want to break down for you what her analysis is and where it is that she goes whoop off the rails before we start looking at who she is and where she's coming from. But I got one more clip for you first.
A stunning decision by a Hennepin County judge throwing out a jury's guilty verdict in a $7.2 million home health care fraud case. Prosecutors say Abdi Fattah Yusuf and his wife ran Promise Health out of a mailbox in a building where several other home health care companies were supposedly located. They were accused of buying luxury items for themselves with the taxpayer money they allegedly stole, overbilling Medicaid and the PCA scam. Even though the jury swiftly convicted Yusuf, Judge Sarah West says there wasn't enough direct evidence that he knew fraud was occurring in his company. Jurors I talked to were surprised. Listen to this.
I am shocked.
Was
I'm shocked
occurring
based
in
off
his
of
company.
all of the evidence that was presented to us and the obvious guilt that we saw based off of the said evidence that this case would be thrown out. It was not a difficult decision whatsoever.
The Attorney General has already appealed this decision. I'm Lou Goose. Follow for more news.
So the jury themselves are like, what the heck happened here? How could this possibly be? And I'll show you what she said. I'll show. We're gonna look at her thinking here, so we have a better understanding. We'll do that in just a moment. First, I just want to get to a couple of rants and chats, so we can all be on the same page here before we get into that deep dive as to what the heck happened there. So, occupant says, "Is this where the cult is meeting?" It is not at all a cult type of cult. So, no, it's not. But it is where the cool people hang. So. Decimal threat saying the judge that oversaw the trial is complaining how the trial was run. No, that's not exactly it. We're about to look at that momentarily. I saw a question here earlier whether I'd seen this trans Slenderman stabber. I don't know about this case. I'm not sure what you're referencing here, Graham. Sorry. No. Let's not forget that those fraudsters have already tried to buy off juries with bags of cash already. I bet the judge found an abandoned brown paper sack on the front porch. I personally would not levy that accusation. I think that people can be motivated by their ideologies just as easily as they can be motivated by money. So, is it possible that you're correct, Gopher? Yeah, obviously, but ideology, and we're going to see that ideology likely played a role here when we get to the assessment of who she is. You'll see that it's. I think that can be every bit as powerful as money. Hey, MLS, good to see you, brother. Here my dues, don't kick me out of the cult. It's not at all a cult. Type of cult. I don't know why people keep saying that. Where does that come from? But let's take a look at the decision here, because, well, it's a doozy. It's quite a doozy. Okay. I'm gonna skip through the whole introduction. I will say this to her credit in her efforts to try and justify this wacky decision. She spent dozens of pages. What page are we on here now? She spent like dozens of pages of going through. This is page 35 before she gets to analysis. Why does it take to page 34? It's a 55-page analysis. The first 30 pages or thereabouts are focused on all of the witnesses who came in and breaking down what they contributed, what they testified about. Now we get into her legal analysis, and I didn't want to burden you with 30 pages of what happened during the course of this trial. So I'm going to just go into her analysis, because even just looking at her analysis without looking at what this person said or that person said, you can see where she's coming in here on tilt. That she doesn't follow her own instructions as to what she's supposed to do. So I'm going to walk you through that. Mr. Yusuf was charged with 1 count of racketeering, 6 counts of aiding and abetting, theft by swindle. The court granted the defense motion for a judgment of acquittal related to the racketeering counts, so I ready to let him go on the RICO charges and the close the state's case. As such, the facts and findings deal solely with the remaining counts of aiding and abetting theft by swindle. A person commits this offense by obtaining for himself or another the property or services of another by swindling, whether the artifice, trick. So, okay, we don't need to get into that. You have to establish that there was intent. Yikes! That didn't go the way I wanted to. Let's draw. All right, we'll use this funky looking pen. I like it. When I go to draw, I can't scroll down on Word. I was trying to use this on Adobe. I had trouble because it was signed, and they didn't want to let me edit it because it was signed. Well, that's annoying. All right, so we're gonna have to let's refresh this. Okay. So you have to establish intent. That the intentionally means the defendant either had a purpose to do the thing or cause the result specified, or believe that the act performed by the defendant, if successful, would cause that result. In addition, the defendant must have knowledge of those facts that are necessary. So you have to have knowledge and intent. The essence of a swindle is cheating another person by deliberate artifice or scheme. A swindle may also be accomplished through a false representation or representations to another in order to obtain that person's property or services, so long as the defendant, there we go, that's what I was looking for, knew or believed the representation to be false. The representation was material, and the defendant intends the Minnesota Department of Human Services to believe the representation and Minnesota Department of Human Services. She's going to try and say here that he was not directly involved. There's not enough circumstantial evidence to establish that he was the one doing the swindling. That's what she's based. This is where she's ultimately trying to get to. They have to show that he knew that he was the one doing the swindling rather than some family member or something like that. That there was swindling happening going on. The defendant is guilty Oh gosh, why is it doing that to me? That's so annoying. Picture format. Defendant is guilty of the crime of theft by swindle committed by another person or persons. The defendant played an intentional role in aiding the commission of that crime, made no reasonable effort to prevent the crime before it was committed. Intentional role includes intentionally aiding, advising, hiring, counseling, conspiring with, or procuring another person or persons to commit the crime. Okay. Yusuf claims the evidence is insufficient to sustain a conviction of the aiding and abetting of theft by swindle charge, arguing that the case relied almost wholly on circumstantial evidence. So that's the key thing here, is that it was almost wholly on circumstantial evidence, and that specifically that each count required the jury to find at minimum that Mr. Yusuf intentionally aided another by knowing that others were going to. He had $1 million in his bank account, and that he intended his presence or actions to aid the crime. He had $1 million in his own personal bank account. Further, that there was no direct evidence of these elements for the reasons set forth below. The court agrees. Following a guilty verdict, district court should apply the same standard as an appellate court would apply in post-conviction. So once we've got this, once the trial is over, I now shift over that I'm in the role that an appellate court would have, based on the when I'm assessing the sufficiency of evidence for a motion for acquittal. In such case, the court must analyze the record to determine whether the evidence, when viewed in the light most favorable to the conviction, and this is really key language here, right? She's supposed to be looking at this in the light most favorable to the conviction, was sufficient to permit the jurors to reach a guilty verdict. Now, this is different standard than we normally would have. Excuse me. Normally, we would have a standard of where we're supposed to be, we're supposed to be balanced, or when a movement is bringing a claim, you're usually looking in the light most favorable to the other side. Over here, since there's already a conviction, the defendant is now a movement saying set it aside. So in this context, it's a motion for summary judgment where the assumption is you lost. You had your bite, you lost. So the only way we can help you out is if we look at the evidence in the light most favorable to the government, most favorable to upholding the conviction, and say, even looking at it from their side, there's not enough here to convict. You have to see whether or not that was sufficient to permit the jurors to reach guilty verdict. The court should assume the jury believed the state's witnesses. This is a key thing also, that you have to say that they believe this. They believe that. Oh gosh, this thing is so annoying to me today. And disbelieved any evidence to the contrary. So again, over here, you have to establish that you have to start with an assumption that, hey, they thought that the defendant's liars were garbage. The court will not disturb the verdict. The jury acted with due regard for the presumption of innocence and requirement of proof beyond a reasonable doubt. Could reasonably conclude that the defendant was guilty. So if you can punish offense, you must find him guilty. Where any material evident element is proved by circumstantial evidence, the appellate courts have applied a heightened standard of review. What is this heightened standard of review? The circumstances should not only be consistent with the defendant's guilt, but they must be inconsistent with any other rational conclusion. This is her way of, this is where she starts cracking open how she's going to try and attack this conviction. That has to be inconsistent with any other rational conclusion. Where any material element of the charge is based on circumstantial evidence in order to find the defendant guilty, the jury must conclude the facts proved by circumstantial evidence must be consistent with each other, and must exclude every other reasonable conclusion except that of guilt by the defendant. So this time trying to find his innocence. Let me just move this out of the way because this is going to be annoying me later on. It's that stupid picture in the background that's making everything terrible. Let's just delete that, right? Where the state case rests largely on entirely circumstantial evidence, the trial court must apply a so-called Al-Nasir Silvernail analysis. What the heck is that? What does that even mean? Under that analysis, there is sufficient evidence to sustain the conviction if and only if no other reasonable rational inferences exist that are inconsistent with guilt. Okay, that's what your Al-Nasir Silvernail analysis is. To determine whether the circumstances provided are consistent with the defendant's guilt and inconsistent with any other reasonable hypotheses, the court applies a two-step analysis. First, it has to determine the circumstances proved giving due deference to the fact finder, in this case, the jury, and construing the evidence in light most favorable to the verdict. So first, we start off by assuming that they got it right. Second, the court must determine whether the circumstances proved are consistent with guilt and inconsistent with any other rational or reasonable hypothesis. And again, this is where she's going to end up trying to make her hay and trying to establish that they got it wrong. The analysis required the court to look at the circumstances proved not as isolated facts, but rather as a complete chain that, in view of the evidence as a whole, leads so directly to the guilt of the defendant as to exclude any reasonable evidence other than guilt. Now, in doing so, you have to defer the jury's determination as to what circumstances were proved. All of this is her way of trying to concoct some way of saying that looking at their witnesses, I still don't think there's enough here for them to find for guilt. In other words, the analysis gives no deference to the fact finder's choice between reasonable inferences. So if they decide to choose this inference, but then there could have been another inference, I don't have to come to that same conclusion as them. So where the evidence establishing guilt is largely circumstantial, the court must identify all reasonable inferences that can be drawn from the circumstances proved by the evidence and determine whether those inferences support any rational hypotheses other than guilt. Now, this is where she starts going off the rails. This is where she's starting to say, I need to try and figure out how I can acquit this guy based on the fact that there could be a possible other inference that could be drawn from this. That's essentially what she's saying here. If the facts viewed in light most favorable to the verdict establish any reasonable rational inferences which are inconsistent with guilt, the state has not presented sufficient evidence as a matter of law. Now, this whole thing here, the way she's interpreting and understanding Al-Nasir, it seems as if she's basically found herself a basis to go on a whole exploratory expedition to try and sift through the evidence to see where can I find something that could be reasonably interpreted a different way and toss that out. Because since it can be interpreted a different way, now I have a basis to basically say this is not reasonably relied upon by the jury. And since they did, I have to ignore what they said here. Let me say that one more time because this is important. What she's establishing here is that she's going to start ferreting through all of the circumstantial evidence and start identifying one by one what other reasonable conclusions could be drawn for the purposes of trying to say, since there's an alternative, non-guilty, reasonable inference that can be drawn from this piece of evidence or that piece of evidence, now I have a basis to say, you, the jury, were obligated to find that other reasonable inference. And since you didn't, I'm setting this aside and I'm going to give him, the defendant, the benefit of the doubt on this, notwithstanding your findings. Now, there could be two reasons that someone would do this. Someone would go on this level of detail as far as trying to figure out this whole thing. Number one would be that they feel as if they are a champion for justice, And it's their job to sit there ferreting through the entire case, which is likely how she views herself. But the motivation to do this and the way she reaches her conclusions about some of these things, saying that's, another reasonable alternative, this is where she starts displaying that she's practically treating this defendant as if it's her own child, because she ends up saying that these reasonable alternatives, you have to question, are they really reasonable alternatives or not? Or are they really grossly unreasonable, particularly when you take them in context with each other? So when you take them in context with each other, and you look at this entire pie, you can't say that if you look at an entire pie, which has a Boston cream pie, and it's got this picture on that's been drawn onto it with an icing. You could say the icing happened to fall on the pie in this center. That's where you start going towards unreasonable bases to try and say, well, it could have happened. I mean, icing could happen to drip out on the cake. But it's like when you start getting to a certain point that you're desperately trying to find it and say, well, that's a reasonable explanation also. That's reasonable also. And that's, since they didn't consider that, I have to throw out that piece of what they considered. That's where you're displaying that you're not simply trying to be a champion for justice, but that you actually are driven by an agenda, an objective, that I have a goal of where I want to get to, and now I'm going to find ways to leapfrog it back and forth in different directions to try and find some way to reach my stated objective. I'm going to pause for a moment just to catch up on some of the chats that came in here. So your stream is jittery and bad audio? Oh, God, no, not again. Stream is clipping and popping all over the place, driving people insane. All right. I actually restarted my computer before I did this. I apologize. I was in my zone. We're good now. All right. I'm getting a lot of this. It's okay now. It's good now. It's good now. You're good now. Phew. Oh, God. Don't. You see, Jim had my back. Thank you, brother. How long was it bad for? So some of those messages came in like 10 minutes ago. All right, I'll get back into my zone. I'll get back into my zone and make sure I didn't miss any rants that popped up. People yelling at me about my audio sucking. 15 minutes. Lord. 20 minutes. All right. The state's case was based on substantial and circumstantial evidence. She starts explaining what direct evidence is that's based on personal knowledge. Okay, as it relates to this motion, the parties are mostly in agreement as to fraud occurring at promise. So even the defendants agree that there was fraud here. That happened. And much of the evidence related to the same. So we're all on the same page. There's been fraud here. Okay. Specifically, the state argues that the evidence of fraud at promise consists primarily of the following. Defendant started as the 50% owner of promise. So this we got. So he's the owner here. Okay, that's one thing. He later took over as the 100% owner of Promise, even falsely stating he had no relationship with Lul Ahmed. So this guy is the owner. Just to follow up here. Did they cut your closing speech on Nate? Was it your microphone? I think they cut me. Pretty sure they cut me. But that happens. But thank you for your concern, Daniel. In fact, invariably it happens. That's kind of the point. The registered location promise was a mailbox. So he's the owner and he only has a mailbox. Okay. Medicaid is state and federally funded program. Records of services provided are required to be kept for 5 years. Identification, explanation of claims. Explanation of background studies and identifying a list of people who are past background studies. Ms. Mahmoud's testimony was that she created fraudulent records for recipients at Promise and listed defendant on the documents. Summaries listing how many hours services recipient received to approved to receive with captions of billing information. Incomplete timesheets that did not include the hours that services were provided. So that also looks pretty fraudulent. Timesheets that had more services billed than were documented in them. That's also a problem. A little bit of a problem. Blank timesheets pre-signed by a provider without any identified recipient in them. Timesheets for recipients who did not even receive any services from Promise. So all sorts of crazy shenanigans that are happening with this limited liability company that he owns 100%. Abid Id is a responsible party for recipients. Abid Id, a responsible party for recipients reported to receive services from Promise, testified received $50,000 from the defendant. So this guy got it from the defendant. A gift letter promised $50,000 to HM for a house that she now owns. HM was also a responsible party for recipients reported to receive services. Kayla Gatoske emails and testified that she was concerned the recipient was not receiving the care that he was reporting, asked to see the Promise records. Promise acted as the liaison to Mrs. Gatoske could not directly speak to the responsible party recipient. Text messages showing payments to other responsible parties. Ramo Muhammad testified that she never provided more than 6 hours of night services a night, but claims that show that 48 units, 12 hours of night services were regularly billed. So double billing on her time. Testimony of Saeed Salah that he trained defendant to payroll for Promise. So this guy knew how to do it properly. Testimony that a background study was required to work directly or indirectly with Medicaid recipients and operate healthcare. Yet Muhammad Yusuf was never submitted for a background study at Promise. A list of people who passed background studies and were eligible to work at Promise. Bank records showing over $1 million in payments to defendants. So his company is paying him $1 million that they're getting with all these shady practices. Over $2.5 million in payments to people who had not passed background studies. They were not employees of Promise. So his company that he owns 100% is kicking out money by the millions. His crazy purchases, his purchases of furniture and clothing, and getting a Mercedes and Jaguar, and on and on. As clear from these facts, there's no direct evidence as to Mr. Yusuf's part of the fraud of Promise. Really? Okay, that's true. It's not direct, it's circumstantial. Rather, this information concerning the claims made, the structure of Promise, issues with timekeeping, and other made to non-employees as well as responsible parties. However, there's no direct evidence of Mr. Yusuf's participation in, knowledge, or aiding in the fraud. There's not direct evidence, but there's certainly circumstantial evidence. The court finds the elements necessary for Mr. Yusuf's intentional aiding and abetting fraud was proved by circumstantial evidence. Oh, okay. So it's proved by circumstantial evidence. Let's prove him. Let's convict. Let's. Then now we're guilty, right? No. As such, element one of the related requirements for intentionally aided were proved by circumstantial evidence. Okay, so we're proven by circumstantial evidence. Why are you letting this guy walk? As circumstantial evidence was used to prove the intentional and intentionally aided elements of aiding and abetting, the Al-Nasir-Silverman analysis then starts with determining the circumstances proved. In identifying the circumstances proved, the court must defer the jury's acceptance of proof of such circumstances that are consistent with their verdict, and the rejection of evidence of the record that conflicted with the circumstances proved by the state. So, what does this mean? It means that they have to consider whether hold on a second. We have to accept what the jury has come to and the fact that they may have rejected certain evidence that they thought was not compelling. Fine. So, what evidence are we talking about? Promise was founded by Mr. Yusuf and his wife with full ownership, later transferring to Mr. Yusuf. The majority of the time frame the charge is in question, he was the sole owner. So we've got him as the sole owner. We know that this whole thing was operating out of just some stinking mailbox, right? We know that he was reimbursed for those services by Medicaid. They paid him millions of dollars. This federal program. That his brother acted as an employee and de facto manager of Promise despite not being listed as an employee. Okay. And he never passed any background checks. Mr. Yusuf's cell phone number was used to communicate with case managers, so they used his phone to do all this stuff. Muhammad Yusuf operated a number of other healthcare-related agencies that were the subject of investigations. So he's done this. He's got a propensity for this type of thing. Several examples of issues and timesheets not including the actual hours of services, not having the required signatures, or other issues that cause them to not comport with Medicaid requirements. In addition, there were examples of claims being submitted with wrong supporting documentation in the wrong format. Mr. Mahmoud fraudulently created required documents for Medicaid recipients. She did this at the direction of Mr. Muhammad Yusuf, Mr. Yusuf's brother, who was hired by Yusuf. She had a background as a case manager, and she created documents without speaking with recipients, and she basically was acting in obvious fraud here. Ms. Mahmoud met Mr. Yusuf on one occasion, but not otherwise see him at Promise or interact with him. She did not believe he knew the documents she created for Muhammad Yusuf. That's what she says, but you're not allowed to. This is where she starts. This is where the judge starts going off the rails. This is what she says. She says she did not believe the document she created for Muhammad Yusuf. You, the judge, cannot consider that. Why can you not consider that? Because you must look at and reject evidence that hurts the state's case. You must reject that. So we see here in number 9 that she's basically saying she did not believe that the defendant knew of the document she created for Muhammad Yusuf. Well, maybe she's telling the truth, or maybe that part of what she said was a flat-out lie. Maybe she was lying. Maybe the jury didn't believe her. You have to assume that the jury heard her on that statement and rejected it. But you, Judge Sarah West here, decide, I think that's what she said. They have a right to hear evidence and believe some of it and reject others. You just said that up here. Their rejection of evidence that conflicted with circumstances proved by the state. They can have, you have to accept that. The court must defer to the jury's acceptance and rejection. So you now are throwing in here in number 9 that Mr. Muhammad Yusuf only met on one occasion, but did not otherwise see him at Promise and did not believe he knew of the documents she created. This here, right here, this is not something you can consider because that is helpful to the defendant. And you just said up above that you must reject anything from the circumstances that are helpful to the defendant. But you, Judge Wacky here, decide I'm going to say, well, I only met one time. How do you know? Maybe he was there every day. You don't know that. Ms. Mahmoud stated that Mohammed Yusuf had forged documents in open businesses in her name. Some responsible parties were paid funds from Promise in violation of Medicaid requirements. Mr. Id received a check $50,000 from Mohammed Yusuf. Again, this is the defendant's brother, is Mohammed Yusuf, and Mr. Yusuf. So he got money from Mr. Yusuf. Oh. Mr. Id understood to be from members of the mosque to which they all belong. Mr. Id was responsible party for recipient receiving services. Hodan Mahmoud was responsible party for Medicaid recipient, received a $50,000 gift from Promise. So that's more money coming out from this company that this guy alone owns. Communication about this gift was between Mohammed Yusuf and Hodan Mahmoud. Gift letter related to the gift noted that the money was from Hodan Mahmoud. A large amount of money, over $2.5 million, was paid to individuals by Promise, even though they had not passed the background studies required. So you're saying that he has no responsibility to know what's happening with this company? That's a reasonable thing. That's a reasonable perspective to take. He's got a multi-million-dollar company. He's not responsible to know what's happening there. Cash App payments made by Mohammed Yusuf to recipients and responsible parties utilizing Promise funds. Checks made out to Mr. Yusuf, Mohammed Yusuf, Lul Ahmed, Mr. Yusuf's wife. So he and his wife are basically bilking and getting this money and sending it to his brother, to his wife. Mr. Yusuf received substantial payments from Promise account, but did not receive a salary. So that's not something that shows that he knows what's going on here. Yeah, but he's just getting substantial payments, but we're just going to assume it's unreasonable for them to conclude that he was acting knowingly here. During many times, Promise bank accounts were being used to make payments to individuals to purchase retail items. Mr. Yusuf's personal bank account was being used in locations in the Bemidji area of purchases like gas, tires, and other regular daily purchases. So it seems like that he's using their bank account, which you would expect him to be using. So he's involved with it to use for his day-to-day activities. We know that there was $400,000 cash withdrawal. Payments were made from Promise bank account to Mr. Yusuf's bank account. Oh, so that you would think is kind of significant as far as showing he knows what's happening here. Some of the non-employee recipients of payments from Promise were family members of Mr. Yusuf and Mohammed Yusuf, including their sister and mother, as well as the whole family organization here. Number of claims, including the charge in this case of $44,776, resulting in payments of $7,257,000 of medical fees. So next, the court must identify all reasonable inferences that can be drawn from the circumstances. Let's see what you consider to be reasonable inferences and determine whether those inferences support any rational hypotheses other than guilt. While there's evidence of fraudulent, negligent business practice at Promise and payments made to non-employees, responsible parties, and other inappropriate individuals, there's no direct evidence of Mr. Yusuf's knowing participation in the same. He got money, $1 million, into his own account. But you're saying, there is no direct. Right, there's circumstantial. First, necessary to review the inferences that can be drawn concerning his role in Promise. Mr. Yusuf was the owner, and it is reasonable to infer was allowing Mohammed Yusuf to operate the business. The reasonable inferences in the circumstances proved do not clearly, and to the exclusion of all other conclusions inconsistent with guilt, show Mr. Yusuf knew and intentionally. The reasonable inferences from the circumstances proved to not clearly and to the exclusion of all other conclusions inconsistent with guilt show Mr. Yusuf knew and intentionally aided in whether in action or by his presence the fraud. What about the fact that he got millions of dollars and was using that account every day? What about that they were raking in millions of dollars when he knows that all they have is a mailbox? What about that? He knows that there's no physical location. There's millions of dollars coming in and out of this company, and he and his family members are basically soaking in gobs of riches, and he's buying himself houses based on all the services provided. But you're saying we don't know. There's other reasonable explanations. What other reasonable explanation could you have for that, honey? Mohammed Yusuf signed checks, delivered payments, made cash app payments, communicated with service providers, used his personal email and phone number to conduct promised businesses. He dealt with the landlord of the location, which promised mailbox, and he instructed the fraudulent documents creation by Miss Mahmoud. Mohammed Yusuf was operating Promise. It's reasonable to infer from Mr. Yusuf's ownership Promise, lack of engagement in the daily activities of Promise, where he's using the credit card every day, and frequent purchases in the Bemidji area during the relevant times that Mr. Yusuf was allowing Mohammed Yusuf to run Promise. Okay. This is clearly a regulatory violation of how Medicaid-funded healthcare agencies should be run. Regulatory violations not always equate to criminal actions. As such, Mr. Yusuf allowing him to operate Promise not enough to establish a basis for aiding and abetting theft. What about the fact that he made millions of dollars from this? The facts concerning the structure of payments from Mr. Yusuf as the owner, as well as his receiving training related to payroll, illustrate his participation and knowledge of some parts of Promise's business. The facts relate to the direct fraud documents created by Miss Mahmoud. So she's saying there's no testimony or evidence of Mr. Yusuf directly carrying out these payments. He got the payments also, though. A reasonable inference from Mr. Id's testimony and this point of determination is that Mr. Yusuf believed the payment was to assist Mr. Id as a member of the mosque. Oh, okay. All right. What about the money he got? U.S. bank account, Mr. Yusuf and Lul Ahmed signatories. So other people have control of the account also besides him. But signatures that are purported to be Mr. Yusuf's vary. This is not your call. This, again, is a circumstantial evidence, which is not your call. That's the jury's call. Some that seem to be directly tied to him, such as signature card for U.S. Bank, was done by e-signature. Most of the signatures appear as Cabdifata. However, in one location, the signature reads Abdifata Yusuf. His signature is missing from most of the places where he could have endorsed a check and withdrawals. While there are signatures of Cabdifata on items in his personal account, it is unclear whether they were actually signed by him. The variation in the signature, as well as some checks, payments, etc., occurring on days during which Mr. Yusuf was, according to debit card activity on his personal bank account, he was in the Bemidji area, making it reasonable to infer, when viewing it in totality with the knowledge of Mohammed Yusuf's forging and opening business in Mr. Mahmoud's name, clear direction on fraudulent activities, and that he was conducting all of Promise's business, is that Mohammed Yusuf was carrying out the payments and fraud without Mr. Yusuf's knowledge or assistance. Here's a question for you. Here's a question for you, Judge. If it's not reasonable to conclude that because Mohammed could have just signed his own name because he too was a signatory. So that's not a reasonable explanation. The inference that the state would like the court to take from every part of the evidence is that Mr. Yusuf participated and knowingly assisted his brother in the fraud committed at Promise. You mean because he made money from it and his wife made money from it? Oh, okay. Some of the basis for the belief of fraud being committed is from the wide-ranging and voluminous discrepancies and problems with both the supporting paperwork as well as how the claims were filed with Medicaid. Anyhow, let's fast forward a little bit here. You can see how she's basically trying to find any way possible to pretend that there's some sort of conclusion that could be, there's a possible alternative explanation that the jury had a duty to conclude, to assume. It's like she would call a reasonable alternative, but none of this explains the money. None of this explains the money that he got when he was making this money from a mailbox. So we get to this. Mr. Yusuf greatly benefited financially from his royal promise. He received many payments from promise directly from his personal bank account. Payments to his account were direct transfers from the promise account. Okay. It does not appear as they were done as salary or part of the payroll. Rather, they are individual payments referenced by the states. They were in amounts varying from a few $100s to thousands of dollars. Payments were not on a regular schedule, and there was no evidence that Mr. Yusuf was getting paid through these payroll from promise. Payments did result in significant amounts of money being paid to Mr. Yusuf. What are you going to try to do with this? Given the lack of salary or income through payroll, the payments were Mr. Yusuf's only direct income from promise. Yeah, okay, they still end up being $1 million. His only direct income. He was the owner of promise. He'd be expected to have income from the business. It's a mailbox. It's a mailbox. It's a freaking mailbox. Unbelievable. Given the lack of salary income through payroll, the payments were Mr. Yusuf's only direct from promise. He was the owner, expected to take an income. The amount of his income was significant. That Mr. Yusuf received a significant amount of money from the business does not create an immediate inference that he knew or participated in the fraud or promise. It's a mailbox. As the owner of the business, income, potentially even significant income, is a reasonable expectation or potential expectation from a business. It's a mailbox. It's also a reasonable inference that Muhammad Yusuf made the payments to Mr. Yusuf's account given his clear control of the operation of promise and direction of virtually all payments from promise. It's a mailbox, and he sees his bank account. Therefore, it is reasonable to infer that Mr. Yusuf was paid by promise at the direction of Muhammad Yusuf, because we don't know. Maybe he's the one who paid it. He still would know that the money is coming into account. He spent the money. The large amount of income Mr. Yusuf received from promise, especially when coupled with payments to his credit card, might raise some concern as to the management of promise's funds. However, Mr. Yusuf's income without more evidence of knowledge or participation in the fraud does not establish that Mr. Yusuf aided and abetted the theft by swindle perpetrated by Muhammad Yusuf. There is no other reasonable explanation. This is where she becomes thoroughly unreasonable. This right here, thoroughly unreasonable. She's trying to find unreasonable bases to try and turn over the very obvious conclusion. This right here, large amounts of income without more evidence of knowledge, participation in the fraud. That's crap. The guy's got a freaking mailbox. There's not even an office. It's asinine. This is really, really asinine. So, given all that, she ends up saying, so even though he's the paper owner, even though he makes all the money, because there's a manager there, I can't tell you that he's the one who did it. This is, even though he made all the money, there's other reasonable explanations. This is where you get bizarre, and that's how she reaches her conclusion that given these facts, given these circumstances, a reasonable rational inference that Mr. Yusuf was the owner and on paper involved with promise, but that his brother was committing the fraud. And hence, she's going to say, this is her conclusion. While the court is troubled by the manner in which fraud was able to be perpetuated at promise, the state's evidence did not exclude any other reasonable rational inferences that are inconsistent with Mr. Yusuf's guilt. Of course it did. The fact that it was his business, it was a mailbox business, and he was pulling out millions of dollars from it into his own personal account. while the company was committing fraud. So if you have a business that is running from a mailbox and it's bringing you millions of dollars, how are you not knowing what's happening there? How is that a reasonable thing to say? However, the state overinflates the actual fraud investigation presentation, failed to provide actual circumstantial evidence tying Mr. Yusuf to his brother's activities, and the evidence is insufficient to sustain a conviction for the 6 counts of aiding and abetting that by swindle. As such, Mr. Yusuf's motion for judgment of acquittal is granted. Signed, SJW. Sorry, SSW. It should, her initials should be SJW. Should be. So there you go. That's her findings there. Let's take a look at this judge. When you close the window, stop piping. The audio was rough for 7 minutes. Maybe we should revisit the non-called tracks to make the listening experience smoother. Yeah, I'm sorry about that. I don't know what happened there. I don't know what happened there. Don't know what happened there. It's very strange. Anyhow, let's take a look at this woman. No, I need to get one of those. It's a magic mailbox. She got the magic mailbox. Decimal threat says, doesn't the judge have authority to allow or deny evidence? If so, why bring it up after the jury made their decision? Well, it could be that it's admissible, but that she decided, I don't know. But you could see there where she's parsing out certain things that she's incorporating, exonerating evidence on his behalf. And why would a woman be doing? Why would a judge be doing something like that? Well, let's take a look at the judge who overruled the jury to allow Abdifata Yusuf to steal $7.2 million. Former public defender and former Barclays transaction manager. Miss West is an assistant public defender at the 4th Judicial District Office of Public Defender. She currently handles juvenile cases. This was her back then. Previously, she was contract assistant public defender at the 4th Judicial District of the Office of Public Defender, partner at Hallable Law PLLC, associate at Fafinsky, Mark & Johnson. And how did she get this role as a court-appointed judge? Oh, Soros-backed former Democrat governor Mark Dayton appointed her to this job. That's right. She was appointed this job by a Soros-backed former Democrat governor, Mark Dayton, who then overturned a decision by a jury. Somali immigrants who stole millions were guilty of fraud. This is not accident. This is what these people were put in place to do. So there you go. There you go. Does that answer your question? Does that answer your questions? Soros judge. Excuse me. Now, it's just so you're aware, and because I don't want there to be misinformation on this. She was appointed in 2018. She won on re-election in 2020. So someone's going to fact check me. I know when I say Soros appointed and say, what do you mean? She won an election. You got there. You're full of hot garbage, Joe. No, she was initially appointed in 2018. I actually did a little bit of a dive into that and established that she was appointed. And later won re-election in 2020. And when I was doing my research, because I want to be 100% sure on this, I didn't want to be misleading anyone. I never want to be doing that. I found this. This was from 2018 from the office of Governor Mark Dayton. Governor Dayton appoints Theodora Gatis and Sarah S. West to fill 4 judicial district vacancies. So that did happen. That was back in 2018. But this is that's your woman right there. So the governor was proud to announce that appointment. She later won re-election. She later won an election to keep the job in 2020. It's a 6-year term. So could be SJW, could be bribery. I don't know. I have no reason to think it's bribery, but who knows? Who knows? So hopefully there's an appeal that's coming down the pike. Hopefully that appeal will be successful. We'll see. If there's an update there, that's certainly, if it's a positive one, I'll try to make sure to come back to you with that. In other news, you might have heard Eric Swalwell. You know Eric Swalwell, right? Congressman from California who's now running for governor. Well, this came out on November 12th. Congressman Eric Swalwell names Washington, D.C. home as principal residence and has no California address. This was from the Gateway Pundit. California representatives, don't worry, there's an update here. There's a reason I'm bringing this to you now. California Representative Eric Swalwell has faced a barrage of controversy in recent years from his alleged ties to Chinese spy Fang Fang, to his removal from the House Intelligence Committee over national security concerns, to his infamous on-air mishap during a 2019 interview with Hardball with Chris Matthews. Are they going to share that with us? Because that's always a pleasure.
Who were on the phone listening to the president talk about this swap of dirt for U.S. military aid.
Chris, so far, the evidence is uncontradicted that the president used taxpayer dollars to ask the Ukrainians to help him cheat an election. And the complaint that I've heard from Republicans all last week was that you don't have anyone who heard the call.
We heard something. Always a classic. Always a classic. That's it. That's it. If you give me a quick click like that. But now we have a new revelation raising even more serious questions about Swalwell's integrity and eligibility to serve in Congress. Despite serving as congressman from California's 15th district and claiming hometown Livermore on his official House profile, Swalwell has declared his Washington, D.C. property as his principal residence. Public deed of trust for Swalwell's D.C. home at 209 Street NE, dated April 18, 2022, confirms the property is designated as his principal residence as a condition of the loan. The deed includes explicit language making the borrower liable for false or misleading statements regarding occupancy. This sounds like Tish James all over again. Quote, borrower shall be in default if borrower gave materially false, misleading, or inaccurate information or statements to lender. So material representations include borrower's occupancy of the property as borrower principal residence. Principal residence right here. Under Article 1, Section 2 of the U.S. Constitution, Congress must be inhabitants of the state they represent at the time of their election. That's a problem. In California, maintaining this inhabitancy means holding tangible, verifiable ties to the state, such as owning or renting a residence, registering to vote, paying state income taxes, and possessing California driver's license. But the Elections Code 349 goes even further. Domicile is defined as the place in which his or her habitation is fixed and the place where a person intends to return and remain. If Swalwell's true domicile is Washington, D.C., the city where he has declared his principal residence, he may no longer meet the base requirement to being a California inhabitant. Public record searches have not revealed any home ownership or lease under Eric Swalwell's name in California. So this is how Gateway Pundit is covering themselves to ensure that that they're not committing any sort of defamatory statement. The address most often associated with his background in Livermore, 320 Mitchell Court, is only a 3-bedroom, 1,350 square feet home that belongs to the Mirzwika family who's lived there continuously since 2008, making it highly unlikely that Swalwell resides there today. Failure to maintain legitimate residence in California could expose Swalwell to legal, ethical, and electoral repercussions. A false declaration of residency risks tax violations, misrepresentation to lenders, challenges to eligibility for re-election. Why do all these politicians just struggle to maintain a residence in the place that they're from? They're all playing these games. Politically, the revelation of Washington, D.C. principal residence undermines Swalwell's credibility and fuels accusations of hypocrisy, especially since Swalwell rose to power by attacking his predecessor, Peter Stark, for being out of touch with the district due to Stark's residency outside California. So basically, he sounds like he's full of hot air. Eric Fang Swalwell. Swalwell, can you hear and smell that was not a pretty one. For fairness, supposedly Chris Matthews off camera was sliding a mug across the desk. I've got a mug here. Sounds exactly the same. You can hear. Sounds exactly like what we just heard, right? So that's what we had a couple of weeks ago. But there's more now because Swalwell's trying to strike back. Desperate candidate Eric Swalwell files lawsuit in response to Gateway Pundit revelations and DOJ referral. On November 12th, the Gateway Pundit, in their article Disqualified, I broke a story of Congressman Eric Swalwell's principal resident mortgage involving his home in D.C. Soon after, Swalwell was referred to the DOJ over mortgage fraud allegations by Federal Housing Finance Agency Director Bill Pulte. He made similar referrals against high-ranking Democratic officials involved in mortgage fraud, including New York's Attorney General Tisha James and Adam Schiff. After declaring for California governor last Thursday, in an apparent effort to save his campaign, today, Swalwell filed a civil lawsuit against Federal Housing Finance Agency Director Bill Pulte, alleging violations of Privacy Act and First Amendment in the action. And even though Swalwell's mortgage is publicly available online, Swalwell claims Pulte's referral is based on politically motivated misuse of government databases. Swalwell claims that Pulte used those records to concoct fanciful allegations of mortgage fraud, which he referred to the DOJ. In the lawsuit, Swalwell further claims Representative Swalwell explicitly disclaimed any intent to occupy the District of Columbia home as his primary residence, and a sworn affidavit attached to his mortgage agreement. That affidavit made clear that the home would be wife's primary residence, not his own. However, Swalwell's sworn deed of trust contains no language whatsoever in which Eric Swalwell disclaims that property. So they say he disclaimed it, but it's not there. That seems like it's made up. Nor does he include any affidavit, rider, or statement indicating the home will be used exclusively by his wife, but they will not live there. So what are you talking about? Both Eric Michael Swalwell and Brittany Watts Swalwell are listed jointly as borrower, jointly signed the deed of trust, and the only affidavit they signed pertains solely to DC tax classification for residential property. In short, the mortgage contains no disclaimer from Swalwell, includes no language assigning the home to his wife alone. His lawsuit appears to be a political advertisement as well. The very first sentence of his lawsuit says, since taking office, President Trump has engaged in unprecedented efforts to leverage power. Let's take a quick look at the first page or two of this. This idiocy from this clown. Since taking office, President Trump has engaged in unprecedented efforts to leverage the power of the federal government, seeking retribution against his political enemies. Those efforts have resulted in DOJ conducting a series of high-profile criminal investigations and prosecution nakedly targeting some of the president's most outspoken critics. Defendant William Pulte, director of the Federal Housing Finance Agency, has played a central role in these investigations and prosecutions. Pulte has abused his position by scouring databases at Fannie Mae and Freddie Mac, two governmental-sponsored enterprises, for the private mortgage records. He has every right to do this. So, for the past decade, Representative Swalwell has publicly and vigorously opposed Trump. We stand against Trump. In 2021, Representative Swalwell served an impeachment manager. No one cares about this. No one cares. In True Social, President has referred to President Swalwell as, amongst other things, a lowlife, an idiot, and a total sleazebag. All true. All proven true. All very obvious. They also mentioned that he also mentions he had a Chinese spy. He does that too. He's telling everyone all about me. On November 13th, Pulte formally referred Representative Swalwell to DOJ for criminal prosecution on charges of mortgage fraud. So, just because you're a jackass doesn't mean you're not also a criminal. And I see, I don't understand that. Like, you're in the referral, Pulte alleged that representatives, because I stand against his government, I can't be charged with crimes that I very obviously committed. Okay. I can't be investigated for crimes. I can't. Hands off. Hands off. I'm Teflon. I attacked Trump. Trump doesn't like me. I'm now Teflon. What? What does that even mean? The allegations Pulte's referral are patently false. Indeed, Representative Swalwell explicitly disclaimed any intent to occupy a D.C. home as his primary residence in a sworn affidavit attached to his mortgage agreement. Where is it? Where is it? Affidavit made clear that the home would be his wife's primary residence, not his own. Representative Swalwell was and remains a permanent resident of California. I guess his California pad is where he keeps Fang Fang. He leaves his wife in D.C. I guess that's what he's claiming is what happens. No, I'm there in California all the time. But Pulte's referral to the Justice Department is not gross mischaracterization. Reality also represented gross abuse of power. Violated the law. Violated it. The referral violated First Amendment to the Constitution in targeting Representative Swalwell for criminal prosecution based solely on his protected political speech. What? No one's talking about your speech. This is so self-important. So self-important. Then we got the Privacy Act, enacted in the wake of President Nixon's campaign against his political enemies. The Privacy Act was designed to bar federal officials from leveraging their access to citizens' private information as a tool for harming their political opponents. So shame on you for finding me out. He's so pathetic. He's so pathetic. How dare you find me out? Sounded like Eric was sliding some mud out of his Swalwell. Ooh. Not a pretty image. Not a pretty image at all. No, not at all. J.L. Schwalbach, you know, you're making me a day drinker starting this early. If my employees sue me for unbecoming behavior, I'm blaming on the juice. Oh, that's good. I like it. I like it, JH. That's good. That is good. You the same two first initials as me, JH. I just noticed that now. That's right. My initials are JHN. But what does the H stand for? What does the H stand for? What does it? No one knows. Howard Hornblower. So, and we have a winner. Not this one. Not that one. That's not him. Henry indeed. Joseph Henry Neerman. The second. It's not really the second. But that is the name that my grandfather had. My father's father. So. Joseph Heath Neerman. Oh, that would be great. That would be great. I actually always really liked the name Henry. So. Doesn't seem like we're going to make our goal. It's not seeming like it. I have an unstated goal of covering the fallout between Cash and Trump Doesn't seem like we're going to be making it today, but that's okay. That's okay. All right. Moving on. Breaking. In a huge FO moment, the FBI is setting up interviews with the Seditious Six. Yes, the Seditious Six Democrats who demanded the military and CIA rebel against President Trump. Both the Pentagon and FBI are all over this. These Democrats have cooked themselves. Now follow through and hold them accountable. This is very, 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 very important. Very important. That's not bad. That's not bad. Now follow through and have them held accountable. Well, we'll see. We'll see. I got a lot here on this story. So the FBI is having interviews. They're being searched. They're being inspected. To find out, hey, where'd you get your script from? What was that about? Who came out and approached you to make this message? How did this whole coordination thing work? And we're going to find out, by the way, during the course of this story, it wasn't supposed to be the Seditious Six. It was supposed to be the Seditious Seven. Who's the seventh one? We'll get there. We're going to get there. But first, let's hear Senator Slotkin complaining about this. Last night, the FBI Counterterrorism Division appeared to open an inquiry into me in response to the video President Trump did not like. No, in response to the video that seemed very illegal. President directed the FBI target us. This is exactly why we made this video in the first place. Idiot. In the first, he believes in weaponizing the federal government. Oh, you mean like Obama did? Not even close. Not even close. Where were your messages then under Obama? Against his perceived enemies and does not believe laws apply to him or his cabinet. Idiot. He uses legal harassment. What law did he break? He used legal harassment as an intimidation tactic to scare people out of speaking up. This isn't just about a video. This is not the America I know, and I'm not going to let this next step from the FBI stop me from speaking up for my country and our Constitution. Yeah. You're a hero. You're a real hero. Now, the real focus, as we said yesterday from Hegseth, is Mark Kelly. And Molly Hemingway points out that Mark Kelly has a history of doing things that question his loyalty to this country. Specifically, in light of his recent call for military insurrection, worth remembering that Democrat Senator Mark Kelly vociferously defended General Mark Milley for placing a call to Chinese officials warning them about Trump in 2020. He also, let's cover that first. Democratic Senator Mark Kelly defends Mark Milley's alleged warnings to China. Senator Mark Kelly defended former Joint Chiefs of Staff Chair Mark Milley for allegedly telling his Chinese counterpart that he would warn Beijing of a prospective U.S.-led attack on China by the Trump administration. The moment came during Tuesday's confirmation hearing for retired Air Force Lieutenant General Dan Kane before the Senate Armed Services Committee. President Donald Trump nominated Kane in February to lead the Joint Chiefs of Staff and fill the position of fired Chair Charles Q. Brown, a major proponent of the so-called DEI in the military. When given the chance to question Kane, Kelly referenced Milley and the Trump administration's investigation into the armed force, into the retired Army general's conduct while serving as Trump's Joint Chief of Staff Chair. Pete Hegseth yanked Milley's personal security detail and clearance earlier this year and directed the Defense Department's new Inspector General to conduct a review board to determine if enough evidence exists for Milley to be stripped of a star in retirement based on his actions to undermine the chain of command during Trump's first term. In 2021, it was reported that while serving under Trump, Milley told his counterpart in the Chinese military that the U.S. had no intention of attacking China and that he would call Beijing ahead of time if Trump were to launch such an offensive. This sounds. How can you get more seditious than this? A military spokesman released a statement that same year confirming a general's talks with the Chinese. The statement did not specifically deny the reports of Milley allegedly informing his Beijing associate that he had warned China ahead of an impending U.S. attack. When discussing the Trump's Pentagon ongoing inquiry into Milley over the reported incident, Kelly, a Navy veteran, stunningly applauded the retired general for his alleged decision to notify his Chinese counterpart of any prospective U.S. offensive. And this is the key part why we're covering this now. Milley's now facing investigation. This is Kelly talking. Milley's now facing investigation by this administration and possible demotion. This is allegedly because he, in coordination with his then Secretary of Defense, Mark Esper, made phone calls to Chinese military officials to reassure them that the United States was not going to launch an attack preventing unnecessary conflict. General Milley did this out of deep respect and commitment to the Constitution of the United States, in my view. Wow. Wow. So, ignoring chain of command, just going out there and consorting with the enemy, saying, I'll warn you of an attack and I'll breach my constitutional duties. That's deep respect and commitment to the Constitution. This is how twisted Mark Kelly is. This is how twisted this sick senator is. It's unbelievable. He also started a spy balloon company funded by China. Former astronaut and U.S. Navy captain who has represented Arizona U.S. Senate since 2020. Helped China create spy balloons. Oh, that's nice. There you go. He's a real patriot right there. Now, yesterday I shared with you how Kelly reacted when he heard what Hegseth had said. Kelly had reacted with this whole thing about how special and important and unique he is, and talked about how since he was 22 years old. I shared this post with you yesterday about how he said about how he's done all these heroic things, and maybe he has. I don't know. And here's a picture he attached to it of all the medals and stripes he earned. Well, he got trolled by Pete Hegseth today. So, Captain Kelly, not only did your sedition video intentionally undercut good order and discipline, but you can't even display your uniform correctly. Your medals are out of order and rows reversed. If you are recalled to active duty for a court-martial, I'll start with a uniform inspection. Oh! I should give you a heads up that there is a question as to whether or not a politician can be recalled to active duty. There is a question about that, a legal question, which could help insulate Senator Mark Kelly. Could, at least while he's a politician. It could in fact be a problem for him. But I mentioned how they were supposed to be the seditious seven, and who's number 7? Senator Ruben Gallego, giving almost the same message here.
First of all, it's a matter of free speech. Number 2, what they said was basically restating what we all know. You, as a member of the military, have a right to disagree with illegal orders. Now, they didn't say what the illegal order is. They don't have to. They're just doing a frank reminder.
No, they did a frank reminder in the context of he has been and will be and will likely be giving. He has been giving unconstitutional orders and will likely be giving more. So that's the problem. That's the problem. The left is desperately trying to defend this. They're desperately trying to defend this as they're just telling them what the law is. Everything's true about the law. What, you don't want them to follow the law? Here's the thing. Here's the thing. It's a well-known tactic that if you start with a false given and then say, and then I'm going to say something that everyone already knows, that it helps bolster the false given. Plus, over here in this context, it's actually giving them direction based on that false given. So, let me give you an example. I was like trying to think of like what's a good example that's not going to be like filthy. The example I'm going to give you is kind of gross, but you have to give a gross example in order to make the point. Okay. Imagine I say about you, you know, to a third party. I'll call you just John, random. Is that random enough? I'll call you Doe, okay? So, because Doe is less likely to be your name than John. Man, I hope every time Doe eats his dog feces, he really should brush his teeth before kissing his kids goodnight. Now, I would hope that, in fact. But you're basically saying and making some crap up and then afterwards giving something that like, well, yeah, that's pretty obvious. Hello. But you're starting with the fiction and throwing that in front. I hope every time Doe eats dog feces, he should really brush his teeth before he kisses his so we're going to say, no, he shouldn't. Or yes, he should. Either way, the point is you're basically saying that first part is what's happening. And that's exactly what these now we have 7 idiots are doing. But they're trying to make it as if like they're saying that this is what's happening. Plus, what's worse yet is that they're giving direction that they're almost implicitly threatening that they're going to be prosecuting anyone who's following his orders and that they'll be claiming it's unconstitutional. They're going to be asserting that these are not constitutional orders. So, yeah, that's essentially what they're doing here. I really dislike these Democrats who are in the military using their service as some kind of moral high mark. 100%. They're Democrats and advocate for the sacrifice of children in and out of the womb via abortions, riots, and now coup. Yeah, and to Frankenstein them and then make them dependent on the government. Democrats are playing that I'm not touching you game. That's exactly what they're trying. That's exactly what they're trying to.
And by the way, I remember either was definitely in boot camp and definitely during our deployment that we also had a reminder that, the JAG officers would come in and say like, hey, by the way, here's the rules of war.
Not in the context of there are unconstitutional orders that are happening.
Everything else like that, right?
Given these perilous times, we have to tell you this now. Given these perilous times, that's the problem.
What they were saying was perfectly sane and in line. What we need to understand is not what it says about them. It's what it says about Donald Trump, that he thought what he was hearing was illegal.
No, it says that they were calling this perilous times and that he's calling for unconstitutional orders, which is arguably illegal.
They're just restating the Constitution of the United States and the oath that we all take. Like, why does he think that is such a threat? First of all.
So here he is saying that he was supposed to be part of that. He was originally supposed to be part of the Seditious 7. And admitting that they had their script, because anything Democrats say is obviously going to be well scripted.
Did you consider why were you not part of this video?
Yeah, actually, so I was part of the first video. The second video is by the time the script got to me and it was in the middle of a lot was going on, I just didn't have time to actually record it. But I'm 100% in alignment with them altogether. this stuff happens. You know, it just happened not to end up being a recording. There's really no other no 3D chess.
The logistics of human life.
Yep.
All right, fair enough.
Weirdo. There's such weirdos. So yeah, it was supposed to be the Seditious 7. Jesse Waters had a good breakdown of this. So let me bring that to you here. Let me break that down for you here. Oh wait, did I miss something? I think I missed it. Pinochet saying Trump's stupid no scalp policy is going to get us all killed, and everything he has done is getting reversed in 3 years. Prepare for the establishment to settle a score with us all, Joe. We are effed. Well, that could be. It could be. I really am still hoping that we'll get rid of the filibuster and we'll have some laws. Ellen says the great Andrew Branca did point out her also might have the defense with the speech and debate clause, especially if it was filmed in Congress. How would that affect the UCMJ is up for debate? I don't think that I respectfully disagree with Andrew Branca that the speech and debate clause would insulate them here. I don't think that would insulate them. It's an interesting thought. But I think the speech and debate clause is Congress being in session, not sanctity of the room. Speech and debate clause protects you, insulates you from any sort of liability if you're a congressman and you get up and you say something on the floor. Broadening that to say that if you're in the building, I don't see how that. I don't think that the speech and debate clause. I'd be surprised if it applies there. Let's put it that way. But he could be right. He could be. I don't know. I do not know. Not sure what's happening here. But Jesse Waters had a great breakdown on this. I actually have 2 clips of him because he did such a good job breaking down this story.
So I talked to 2 CIA officers who said that this is a part of a larger hoax. And what they're doing here is they're trying to condition the country to prepare for something bad that's about to happen at the hands of Donald Trump. It's straight out of the CIA playbook. It's a destabilization operation where you get people to mistrust each other. And you do this because she's an analyst. And as an analyst, she would make sure what propaganda operations were successful, which ones weren't. So she knows what works. So the first part of the video, you established authority. I'm CIA, I'm military, you need to trust us. Second part of the video, they introduce the threat. And the threat's not foreign, the threat's domestic, the threat's Donald Trump. And then at the end, they introduce the solution. What's the solution? You resist, you say no. But they don't give an option. They say this is an obligation for you to do. But she is being run because she didn't come up with this herself. She's a Brennan acolyte, and you usually don't have congressmen and senators doing anything together. They kind of hate each other. So in order to organize this had to have had some sort of
from on high
telling her what to do.
From on high.
And it was risky because nothing like this has ever been done in the history of the country. And you can even tell because the media was skeptical and they couldn't answer the question. So they hadn't even been read in on the operation. You see them fumbling and stumbling. And I'm glad that the U.S. military is now investigating this guy, Kelly, because this is what we expect from Donald Trump 2.0. You can't have the deep state interfering with a duly elected presidency and get away with it. You got to draw the line in the sand and you have to make examples out of people.
Now, one more clip of him, which I think is over here. This was a psych operation.
CIA officers who said that this is a part of a larger hoax. And what they're doing here is they're trying to condition the country to prepare for something bad that's about to happen at the hands of Donald Trump. It's straight out of the CIA playbook. It's a destabilization operation where you get people to mistrust each other. And you do this because she's an analyst. And as an analyst, she would make sure what propaganda operations were successful, which ones weren't. So she knows what works. So the first part of the video, you establish authority. I'm CIA, I'm military, you need to trust us. Second part of the video, they introduce the threat, and the threat's not foreign, the threat's domestic, the threat's Donald Trump. And then at the end, they introduce the solution. What's the solution? You resist, you say no, but they don't give an option. They say this is an obligation for you to do. Now,
and I do think that that is clearly what the objective is here. He didn't really go far enough in saying that the obligation comes with an implied threat. The implied threat being, one day, these people are going to be in power. One day, if I follow Trump's orders today, tomorrow, next week, next month, next year, I could be facing prosecution for following those orders if his orders are deemed to be unconstitutional. So right away, they're trying to bake into the cake here this notion that you are in jeopardy, that you have to sit here, start doing all these equations. Is this, rather than following normal procedure, which is an assumption that everything is constitutional, but that the idea here is to plant a seed in your head that you better consult with an attorney or, ensure that this is actually constitutional. Otherwise, your neck could be in the potential ringer one day down the road. That's what is implied by when they have this weird assertion that there have been unconstitutional orders that have been issued without specifying anything. Not specifying which order they're talking about, what type of orders they're talking about, who are they talking to? Are they talking to people who are supporting ICE? What are they even saying? So they made it purposefully amorphous in that way in order to sow that sort of, it's demoralizing because it makes you question everything about what you're doing. And it also makes you concerned that you're going to face repercussions for doing your job. It's terrible. Terrible people. In the video, the presumptive dog feces was, we know you're under enormous stress and pressure right now. Yeah. Why? Why? How? In what way is there enormous stress and pressure right now? They're the ones who are creating enormous stress and pressure. That's what they're doing. Now that you heard our video, now you're under enormous stress and pressure because you need to be concerned that we're going to prosecute you down the road under a claim that you followed an unconstitutional order. And there's going to be some sort of Nuremberg trial that you're going to be facing, and you won't be able to say we were following orders. That's essentially what they're trying to say. That's coming for you. It's really vile. It's really, really vile. Finally, that's not it. Let's see it here. I was thinking about giving you something, throwing in. Okay. Put it here. We didn't reach our goal, but for one reason or another, I think there's been some sort of I had glitch issues, so I'm going to blame it on myself, and I'm going to act as if we fulfilled the goal and get into this Kash Patel Trump thing, because it's very feasible that my audio glitch issues impacted the audience here. So I'm gonna honor it as if we met the goal. Also, I never put the goal up, so it never went through. So there was all sorts of tech issues we were dealing with tonight. So I'm gonna honor it as if it went through, and you guys are the beneficiary of that. And thank you guys for supporting. Oh, guys, enlisted oath, quote, and that I will obey the orders of the President of the United States and the orders of the efficiency are the orders of the officers appointed over me according to regulations, the Uniform Code of Military Justice, so help me God. I think baked into there is to uphold the Constitution, though. like under the Uniform Code of Military Justice. So, did you see CEO of Campbell's Soup caught in recording saying they use lab-grown meat in their products? No way. No way. Campbell telling Bud Light, hold my beer. What? What? No. Say it ain't so. I never had Campbell Soup. But that's a whole not kosher thing. All right. See, God can be insulated from lab meat. So apparently MS Now and the left are very excited about potential dissension in the ranks, much like the seditious 6 or 7. And MS Now is reporting Trump weighed the ouster of Kash Patel, according to sources. There's always sources. Sources. Patel has come under scrutiny for his stewardship of Bureau records, including his girlfriend's security detail and use of government jet. I don't think any of this happened. I think the entire thing here is designed to be a hit piece against Kash Patel, that he purportedly used his jet plane to meet his girlfriend. I think that's the entire objective here, that this entire thing about him potentially being ousted is crap. President Donald Trump is considering removing Kash Patel as FBI director in the coming months, as he and his top aides have grown increasingly frustrated by the unflattering headlines Patel has recently generated, according to 3 people with knowledge of the situation who requested anonymity in order to speak freely. I feel as if this was written by, it says it's written by Carol Lenning, but I assume that she plays Rita Skeeter in the off-Broadway play. If you know, you know. Patel has come under scrutiny for his stewardship of Bureau resources, including his girlfriend's security detail and use of government jet, and for his squabbles with other Trump loyalists. Trump and the White House aides have confided to allies that the president is eyeing removing Patel and is considering top FBI official Andrew Bailey as the Bureau's new director. I wanted him to be the head. I want Andrew Bailey to be the head of the DOJ, honestly. According to 3 people. Patel is described as being on thin ice, and his ouster appears closer than ever, with Bailey as the logical replacement. 2 of the sources with knowledge of the situation said, though Trump could change his mind in the weeks to come. White House spokeswoman Abigail Jackson responded to MS Now, saying President Trump has assembled the most talented and impressive administration in history, and they're doing an excellent job carrying out the president's agenda. FBI Director Patel is a critical member of the president's team, and he worked tirelessly to restore integrity to the FBI. On Tuesday, Patel was present at the White House for the annual pardoning of Thanksgiving turkeys, where Trump publicly commended him, and that he was very busy doing a great job. When several people applauded the president, added, "So, see, you got a following, Kash." Okay. Wow. Caroline Levitt posted that it was completely made up. We'll get there in a moment. Here's Katie Tur.
Breaking news. MS Now has just learned that FBI Director Kash Patel may be out of a job in the coming months. 3 people with knowledge of the situation say President Trump and his top aides have grown tired of Patel and the unflattering headlines he's been generating recently, including using a government jet to visit his girlfriend and enlisting a SWAT team as her security detail.
You see, that's what this story ultimately is about. That's all this story is. But they want to give it some gravitas. How do you give it gravitas? How do you make it clickbaity? Oh, we have 3 sources that say that Trump is considering removing him. Here's Caroline Levitt saying, that's garbage. She's quote tweeting this story here. And what she writes is, this story is completely made up. In fact, when the fake news published, I was in the Oval Office where President Trump was meeting with his law enforcement team, including FBI Director Kash Patel. I read the headlines to the president. He laughed. He said, "What? That's totally false. Come on, Kash. Let's take a picture to show them you're doing a great job. Do not believe the fake news." So there you go. There you go. That apparently is from today, according to Caroline Levitt. So, if you ask me why it is that this sort of thing would happen, specifically between Cash and Trump today, is because I think there's a couple of reasons. One, they're looking to try and embarrass Cash and do anything they can to embarrass Trump by proxy. So they're basically trying to bring up that he supposedly misused government jets or SWAT teams for his own personal thing. So this is their way of trying to throw that out at you, to try and throw out those allegations, which I will assume, just based on the fact that it's being reported by MS Now, are thoroughly spurious. I don't know, but I would assume, given the fact that virtually every word that comes out of their mouths is thoroughly spurious. Secondly, I think that there's an association, there's a deep association that Kash Patel has, because he and Dan Bongino were the ones who came out there and basically gave the whole trust me bro thing with respect to Epstein. I think it's their way of trying to subtly come back to just focusing there. And that's possibly part of the thought process as well. But the objective is continually, and this is the part of the whole resist movement, is basically let's try and just form dissension in the ranks. Everything we can possibly do to try and make you question the legitimacy or effectiveness of this administration or its major, or any major working cogs in this administration. We're going to try and grind down the gears as effectively as possible. You see that with this report. You see it with the Seditious 6-7. You see it time and again with these activist judges who are sitting there trying to, who are issuing those ridiculous those ridiculous restraining orders. Over and over again, what we've seen during the first year of this administration is a concerted effort by everyone on the left to try and grind and halt the effectiveness and ability for this administration to proceed. Even going so far at times as shutting down the government or helping, or you see, even they get joined on by folks who are purportedly from the right, who sometimes seem very dedicated to principle in ways that are somewhat bizarre. Like Tom Massey saying, let's keep the government closed because he's mad about the bills. Am I mad that we don't have a budget? Am I mad we don't have a budget? 100%. Start working on a budget. But to keep the government closed is, in that context, is asinine. We should be kicking and screaming every day about the budget. He's more concerned with he was more concerned with the Epstein files than actually creating a budget. So, yeah, like I said, everything here is designed ultimately to try and slow down this administration from accomplishing its agenda. That's a good sign. That's actually a sign that they have concerns about this, the steps that the Trump administration has been able to take. At the same time, it's also a call upon Trump that he has to step up efforts to start clamping down on this. I think that there's been a little bit too much kid gloves in his way of handling this. I think that it's time for him to actually start stepping up. I want to see prosecutions, and he has to get on Pam Bondi. I mean, he's got to get on these people who are spreading dissension, not just through tweet or Truth Social post, but there actually have to be repercussions. There have to be repercussions which translate into, in many cases, indictments. We had Tulsi Gabbard come out in the summer telling us all about Obama and Brennan and Comey and Clapper. Nothing so far. Nothing. How long does that take? Anyhow, the more he allows these hits to keep coming without any repercussion, the more the hits will increase. So they're not going to go away. They're just going to get worse. The officer's oath doesn't say anything about following orders. So this is This is in contrast to the enlisted oath that Ogai was bringing up earlier, which says that they'll obey the orders of the president, but the officer's oath doesn't say anything about following orders, just the discharge of the office appointed to. So this video was aimed at the E1 through E9 enlisted ranks. Enlisted, I was both an enlisted and a commissioned officer. I haven't looked at these oaths carefully, nearly as carefully as you have. What I'll point out to you is that irrespective of the oath that they've taken, the wording of the oaths that these enlisted and or commissioned officers have taken, there is an overarching theme that there's no individual who's powerful enough to warrant vitiating, ignoring, disregarding the Constitution. So that if you're engaging in an unconstitutional act, that the president obviously doesn't have the authority to issue an unconstitutional order. And I do think I think they probably was targeting the upper echelons of the military and the Navy. The reason I think that is because they're the ones who are most likely to actually listen to it and take it seriously. They're the ones who are much more likely to be following politics. They're the ones who are much more likely to be Democrats and have it resonate with them. Share with you here a bunch of posts which may give you some heart. I was going to close out, but because of you, Ogai, I'll share with you some thoughts which might, some clips which might give you some heart as to how a lot of folks are reacting to this. I got 3 here. See? You guys can all thank Ogai.
Hey everybody, this is Buzz Patterson. I'm a retired Air Force Lieutenant Colonel, retired Air Force pilot, combat veteran, and at one time I was the military aide to President Bill Clinton and carried the nuclear football and actually lived in the White House. So I've been around. I was actually, during my military service, deployed to 70 countries and fought in 3 wars. So I feel like I've got a dog in this hunt. I am very appalled at what the Sedition 6 has done with their video. I think it's a violation of their oaths of office, and especially in the case of Senator Mark Kelly, I believe it's a violation of the UCMJ, and I hope that President Trump and Secretary of War Pete Hegseth hold them accountable. They are violating, and they are politically using their positions to undercut the command.
That's correct.
President
They were.
Donald J. Trump, and
Very much so.
circumventing the chain of command. Congress and members of Senate are not in the chain of command. President Trump is, however, as our commander in chief. So I fully support going forward with whatever prosecutions are warranted and legitimate, and I think they are. On these individuals, they use their positions, military and in the intelligence community, to expose, I think, and put at risk those of us who serve in uniform. I think that what's going to happen is because they violated the military chain of command, people are going to die. They undercut the underpinnings of the military, which is good order and faith and trust in their leadership. And in my estimation, what they did was treasonous and seditionist, and I hope they are prosecuted to the full extent. Again, my name is Buzz Patterson. I served in combat. I've served for 20 years, and I am outraged by what has happened by the Democrats, and I fear for what's going to happen to our young soldiers, sailors, airmen, and Marines if they choose to violate what is a legal order, which will ruin their lives and ruin their careers. Thank God, guys. God bless. See you.
Spuds 1964 says a color revolution by any other name. Hey, it worked in Ukraine. It's funny that Jake from Oxford Sullivan's wife, Minnie Mouse Maggie, is in the video. I don't know enough about Jake. But got 2 more here. Well, this is Shipwreck Crew. Sorry, this wasn't it. But this is Shipwreck Crew saying Mark Kelly should be worried. It's one thing to tell a member of the military that they do not have to obey a legal order when there's a particular order under scrutiny. When you give a member of the military that advice on spec, not tethered to particular order under scrutiny, then you are merely creating a risk of insubordination by inviting the military member to decide for themselves what orders are legal and what orders are illegal. That you cannot do. And here's another member of the military weighing in.
Hello, I just had to make a quick video for all these pathetic responses to the Seditious Six, and they're coming out saying it's okay what they said. Now people like Vindman are coming out and saying in support of these Seditious Six. But anyway, I just had to do a video for President Trump in support of him as a veteran of a foreign war and sergeant when I got out. Chain of command was everything important. And for these guys to come out and pretend like what they said wasn't true, or what they said didn't have meaning. Words have meaning. They were, 4 of them were officers. 1 was in the CIA. 3 were military officers. And they're trying to pretend this wasn't a big deal. So their seditious behavior should be dealt with. And 100% supported President Trump. And hopefully something will be done. Otherwise, it will continue. Thank you.
It will not just continue. It will get worse and worse and worse. This is how they. This is just like an opening shot. It will get worse and worse. You'd be astonished at the amount of Democrat brain rot and American self-hate that happens lower enlisted in officer ranks. Younger generations of military live on Reddit and Discord. It's really bad right now. I would be astonished. I'm not saying that it's not like 5 to 10%, but I think I'd be surprised if it was 20. I would be astonished. I'd be really astonished. I just don't think that they enlist. Especially under the recent enlistments that happened in the wake of Trump's election. I'm sure there's some. Yeah, using their alleged servicemen to fire the missiles to kill a U.S. citizen in Yemen should be disobeyed Obama? It's a great question. It violated the good order and conduct regulation, which is a violation of the USMJ. Treason trumps all of it. Incite coup d'etat is treason. But the question is whether it's really inciting it. The question is it, I mean, as a legal matter, is it really inciting it? You know, we do have to consider the First Amendment rights of individuals to say we disagree with Trump. But when they're giving them advice as to what they should do, it's walking perilously close to the line. It's good that they're getting a lot of kickback on social media, and they are. It's good. Because, you know, while they're talking a brave front as I'm not going to back down, it definitely has an impact on the next person. They really want to put their neck in the noose. Which is why Senator Ruben Gallego's follow-up is somewhat disconcerting. And I do think we need to do everything to put them in their place. From a legal perspective. Exclusively from a legal perspective. But as far as the law allows. Not some law being implemented by some leftist judge who got the job because they meet the Soros standard, the way Judge Sarah West does. 30 to 40%? No. No way. No way. No way. I hope you're wrong. I sure as heck hope you're wrong, Printer God. I think that's a cynical perspective. All right. That's my show. I'm sticking to it. God willing, tomorrow evening, I will be back here at 6:30. I hope to see you then and there. Until then, I urge you to make sure that you remember that lab meat was never meant for you. It's not yours. Just move on. Just don't even consider it food. Okay? I don't care if they wrap it in a Campbell's bottle, Campbell's can, or in Bud Light. No. It's not meant for you. It's meant for they, them. And what else I want to tell you? Do not eat the bugs. Don't do it. Don't eat the bugs. Thank you all. Have a great night. Godspeed.